Hi, my name is Jim Hilborn,
And I'm Tom Dinas.
and we are the Small Business Doctors.
And I've been taking care of business every day. Taking care of business every way. I've been taking care of business. It's all mine. Taking care of business and working overtime.
Good afternoon, good evening, and we're glad you're able to visit with us again. We're going to talk about, I think, a topic that may not apply to everyone, but certainly applies to a lot of people a lot of the time, and that is, what do you do when you have, as a guy who wants to go into business, woman who wants to go into business, you have this great idea, and you have this either an idea of how to make something or how to do something, and that's going to make you have this incredibly profitable business. And it may not work out just as you've intended, but one thing we are going to talk about is how to absolutely protect your idea from other people taking it from you. Now, in my practice, and I think most of you have watched this before. I'm an attorney. I've been in practice for more than 30 years, and Tom here is a tax consultant and economist, and he's been doing his thing for more than 30 years. And so, we've seen a lot of people come through our doors and who have been successful, and we've seen people that come through and have had, some failures and some, or some adversity to overcome. Our mission in these films is to try to help you avoid all those mistakes, so that if you do have a good idea and it will sell, if you have a service that people want, if you have a product that people want, your business will be successful, and you will not fail because of some failure of understanding how taxes work, failure of understanding how the unemployment system works, all those little business things that most people not in business don't have a clue about. You will know. You won't have to make the mistake that's going to cost you money.
Yeah, our motto is we're going to keep from making mistakes because we can't get you out of the problem once you make them.
That's right. That's
And
right.
So this is like avoidance. We're going to keep you from getting in there and making these mistakes prior to that point, because it becomes a lot more expensive and a lot more detailed, and just it drains a small business when you blunder along. Whereas just a few simple things that you might do over the course of your business career can save you tons and tons of money and lots of time. Make your life a lot nicer.
Yeah. Oh, yeah. Yeah. Knowing this stuff is helpful, and it'll also help you say, gee, maybe I don't need a patent, or I don't need a service mark, or this not what about, this isn't going to hold me up, or maybe I really can go into business and use this idea. And so the first thing I'd like to do is, first of all, a little disclaimer here, I'm not a patent attorney, and I'm not a trademark attorney, and I'm not a copyright attorney. And if you have an idea that's really going to go down that path, and you're going to get to that point, and you really are about to go into production, then, as we're going to talk about, you need to see an attorney who specializes in that kind of, and they really are specialists. And
that really takes a cross. A lot of people don't realize that patent attorneys are an incredible blend of expertise.
Yeah, often engineering guys.
Yeah, they have to be, because they have to go through and do all these checks and analyze all these blueprints of other ideas to see if they're, matched and stuff. It's just really a strange blend, law and engineering. So.
It is, and it goes way back. In fact, I'm going to tell you this, that the right to have a patent was established. This is your history lesson for the day, Tom.
Mm-hmm.
The right to a patent was established over 200 years ago in Article 1, Section 8 of the United States Constitution, and where it says, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries.
Yeah. One of my heroes in life worked for a patent office, Einstein.
Yeah, that's right.
He was, Swiss, but yeah, that's where he came up with theory of relativity and general relativity.
Yeah.
Was during that period in his life.
Oh, when he was a patent clerk. Well, so that makes sense. And of course, then, so let's just go through.
He stole
some-
it from one of my relatives in Eastern Europe.
Okay, and one of your that was the relativity thing. Yeah, okay, the cousin. That's the most ridiculous thing I've ever heard. All right, so let's just talk a little bit about what's what and the difference between a patent and a trademark. I'll read off my notes, and most of this stuff you can get online as far if you want to do the study. I'm just going to point you in the right direction, kind of talk about how to think about it. A patent is a right granted by the government of the United States, and you know, there are international treaties which say that if you get a patent in the United States, that other countries which are parties to that treaty, most of
Which
Europe,
is most of the world
will respect your right. So it is a right granted by the United States to exclude others from making, using, offering for sale, or selling the invention throughout the United States, or importing the invention into the United States for a limited time in exchange for public disclosure of the invention when the patent is granted. Now, what that means is that, first of all, the idea that the government has, or it would be so good to have useful products put on the market that we wanted to encourage inventors to put their stuff out on the market. And then if other people, and that way the inventor could license that right to use his invention to other people if he didn't want to make it himself. And so that's kind of what that means.
And once you patent it, it's public record.
It's a public record, yeah.
You
People
can go on
look
there and you can see the drawings and the specifications, because that's, from my experiences, you know, these things all have to be spelled out in the patent application.
That's right, they do, and it's I don't know if it's online or not, but there's a patent office in Washington D.C. and I know that patent attorneys have access to that office and deep and mysterious ways that you and I can only dream about. But
You know, Jim, and where I see it at my level are, you know, somebody coming in my office and
Right.
they go, I got this really incredible idea. Well,
Right.
what is it? I can't tell you.
can't tell you. That's right. Yeah, I've had that same thing.
I don't know how to help you there.
I've had that same thing happen to me, and I go, well, you know, it is confidential, but no, I can't tell anybody. Well, here's how you. For one last thing, and then I'll start talking about how do you protect yourself. There's three different kinds of patents. The utility patents, which is granted, that's what I usually think about, which is to anyone who invents or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any, which would be like a new metal, or any new and useful improvements thereof. So, and then there's a design patent, which I actually own a little piece of one, or did, may be granted to anyone who invents a new, original, and ornamental design for an article of manufacture. And then plant patents, I didn't even know this till I looked it up, but may be granted to anyone who invents or discovers and asexually reproduces. I know, it's not that kind of program usually, but we had to go there.
We're in new ground.
This is
here.
only for scientific, yeah. Asexually produces any distinct and new variety of plant. So
Right.
we're not going to really
And,
do
yeah,
that.
manufacturing process basically is
right.
what they're referring to.
Yeah, and you know, genetics. So if you get a new type of corn, you can patent it. I didn't know you could. I guess
Well,
you.
not only that, it's say you work for somebody and they're producing widgets of any type, you know.
Right.
And they're using a process, and then as long as you don't have some sort of non-compete clause with the employer, and you develop a new process for manufacturing the same identical thing, only better and more efficiently,
Right.
you can be granted a patent for that processing system.
That's right.
So you could go back to your employer and sell them. You can't manufacture his product if he has a patent on it, but you can sell the process of how
Yeah.
to do it.
Yeah, I think that's right. I think that's right. And so, and of course, those as you can imagine, when we're really talking about something that's a lot of money here, all of these questions come up, and there's can be fights about all of
The
them.
guy
so.
who invented the pulse windshield wipers,
Yeah.
he didn't get his money until just like a year or two ago.
And,
He invented that like 20 years ago. But
Yeah, the
so-
channel locks, you know, that the adjustable wrenches, you know, that was like, took forever, so I got to get his money. The guy here in Oregon, Leatherman, I believe, and I don't know this, I think he's had lots and lots of patent fights. He fights to keep his patent.
Oh,
Yeah, so
There's knockoffs all over the
all
place.
over the place,
I
and
bought
he-
one of the knockoffs that lasted for one fishing trip.
well, I'm glad, you know. And So that's a patent. And then the trademark is what, and this is kind of a simple-minded, it's not a words. And so if you said small business doctors, we can't trademark that.
No.
But we can trademark a logo, what I call a logo, or a service mark is probably more the correct term. And that is some combination of words and design that is distinctive and unique to our business, a brand, if you will. And so you can do that. Now you can do that. There is some, different states have different ways to license trademarks, but the federal, everybody I've talked to said you want to do it federally. And that gives you, of course, that long reaching. So that's, you can make that mark your distinctive mark, and so that no one else can use it.
Yeah.
Okay, so that's a trademark. Now, girls and boys, let's see. And I wanted to tell you what is a copyright is a form of intellectual property law. Did you feel that? Protects original works.
I like your quote that this was going to be simple-minded.
Simple.
I passed up the ability to give you a shot on that one.
You know, hey, I'm just here with the message today. And a form of intellectual property law which protects the original works of authorship, including literary, dramatic, musical, and artistic works, such as poetry, novels, movies, songs, computer software, and architecture. And
Architecture? Really?
yeah, I know. And copyright does not protect facts, ideas, systems, or methods of operation, although it may protect the way these things are expressed. So it would be, the user manual might be copyrightable, even though you couldn't get a patent on what you're doing. So that would be an example of a little difference. Okay. So those are the three different things. Those are the three different ways to protect something. So if you're writing a book or a poem, you would get a copyright. If you have a logo, you want a trademark. And if you have a new machine or a better way of doing something, or a new plant, or a design that goes to making a mechanical process more attractive, then that would be possible.
One of the things I see a lot is that the person who has the idea, and the idea is everything in some cases, but
Right.
It's maintaining the integral part of that idea, and so you keep it to yourself. But you get to a point that maybe you have to move out of your level of expertise.
Right.
And so then the client says, well, I need engineering drawings, or I need to build a prototype. I'm not a machinist, and all sorts of other people coming in on this project in order to make it viable and get it off the ground.
Exactly.
So how do you protect that? How does that work into the game?
And that was going to be the basis. That was going to sort of be the basis of what we're talking about here tonight. So, when the average inventor has an idea and he wants to protect this idea, which I assume would be most of us if we had this idea. Okay, suddenly I know of a better way to build a widget, or a new and better shovel, or some kind of new and better engine, automobile, a better carburetor that'll get 400 miles a gallon. I mean, I've heard of all. What do you do? You have this idea, you've been playing with it, and is it enough to just have the idea? Well, probably not just to have the idea.
No, definitely not.
No, you can't just patent an idea. You have to have the ability to show that it probably is going to work.
Right. You have to have specific drawings. You
Yeah.
have to have engineering work done and drawings done, so the patent attorney has something to work off of.
That's right. And so,
on.
and now in patents and in most intellectual property, time is everything. So the idea that when you need to prove that you had the idea first. Now, that may not make it, we're going to talk about that, it may not make it patentable for you, but it may keep somebody else from getting a patent on it if you want to use this in your own business. So, not maybe a perfect win there, but you have to show that you had this idea. And what you do is you keep what's called an inventor's log. It's a notebook, it's a filing device, and you keep your notes where you sat down and you started working these problems out and started making your rough drawings and you're dating this material and you're putting it
Oh, can't
in a
you
file.
just backdraft that and and do that later, or just phoning it up later? I mean,
Well-
how does somebody know that that log is for real? Is there ways you can document it?
Well, those are all questions that do come up in contested patent cases, as I understand it. And so, any way that you can, obviously, if you can take a picture of the newspaper with your, and it has a date on it, there are some ways that you can do that. But but certainly in your average deal, you want to start establishing that timeline in ways that maybe you can think of that I can't. Ways that you're establishing the timeline of how you're drawing your idea and the progression of that idea. And so that's going to be pretty important to do. That time is everything. I think that's probably going to be true for you if you're drawing your own logo, which I don't know how many people do that anymore, but I suppose a lot of people do. I don't know. And copyrighted material. Copyright's usually the easiest because you have to demonstrate the intention that the material be copyrighted, which is usually by putting a C on it with a big circle around it.
That it?
That's it.
You don't have to register with any governmental organization.
No, you
Or
don't.
pay any fees?
You don't have to send your book to the Library of
simple as
Congress or
put a
anything.
C?
Yeah, you put a C on it, and it's copyrighted.
All right.
And that means that you don't intend to license people to use it. Now there's exception to all these rules, and so I'm writing a paper on something, and I come across your material, and I have what's called fair use, and I can quote you as long as I give you credit for that.
No. So that's why in the bibliography part of the book they have
Yeah,
all the
exactly.
hints
So
and
it's
so-and-so,
okay.
so-and-so.
So and so, Tom Dynas says this in his book, working with Jim Hilborn, the early days,
Big seller. I heard that.
you
It's
what?
really,
Huge,
just
big,
jumping
big,
off the
big,
shelves,
big,
bro, I'll
big
tell
time,
you.
big time. So, and so he would quote you, and that would be fair use to quote you on something like that. And but to take the book and say and change the name of the author, that would not be. And at some point between those two things, it becomes plagiarism and actionable. But
But then you could also, couldn't you use the patent attorneys tend to be more expensive than your run-of-the-mill attorneys, from my experience.
I don't know, but
Could Art, hook up with your local attorney and just, to document some of these steps, and say, I've done
suppose
this,
so.
this, and this,
I suppose
get some
so.
advice on, all this, and then, but that also gives you more credibility because the attorney's going to give you a bill for it, or the accountant is, and so you've got, conference about this or that.
I hadn't thought about that,
Yeah.
but that makes sense to me. I think that's a reasonable idea or something of that nature. And but at any rate, so as you develop this log, and however you're going to prove it, and it may not be important to prove it at all, but it's going to be important at some point to understand that. So we build our widget, and it works. And when we have a test of our widget and it works, and we're excited to get into the widget business, whatever that might be. And so we take the widget and we start using it. Okay, that's okay, and we're testing it, but then we start making a few of them and selling them. So now, at some point, we are into the commercial production of our idea. Now, there is a clock that starts ticking. Now we've entered the stream of commerce without a patent. So that's the point, at that point is when I say, when you have a working model of what you want and you are making plans to enter the world of commerce, then you need to go ahead and start the patent process formally. If you're putting some money on the line, then you're going to want to go to a patent attorney and do that. If you put a product into the stream of commerce for a period of time, and last time I looked up it was 1 year, and without getting a patent, then it is in the public domain. Doesn't mean you can't use it. It doesn't mean anybody else can use it because you thought of it. Again, now you're proving, you're going back and say, wait a minute, it's my idea. You may have put in a patent application, but it's my idea. And the patent would be disapproved on that basis. Of course, you got to watch, you got to be doing it. But so you want the patent, but you certainly don't want anybody else to get the patent.
Now, I've heard this thing where my clients come in and all they really wanted was the patent pending stamp to be able to put on the product,
That's right.
so that they know.
And I had a personal experience with this, so I'll tell you what my attorney told me. No longer just sitting around talking about it.
Yeah.
He said, you know, there really is no such thing. You know, it's kind of, you see that, and it is really to discourage people from going into the marketplace with your idea. But really, as was it Yoda said, there is no try, there is only is and not is. But, you remember that? You know, that's one of my law mentors, Yoda. But anyway, so you either have a patent in the process, and it's going to go to the first person who came up with the idea, or and that patent will either be given, or it will be not given. And so there's, you know.
So, but to get the prototype made, you're
Right.
giving out a lot of information to the person who's going to make it for you.
I think you're going to have to disclose, and that's why you're going to be, you know, you're going to give him something, like I think a receipt, you know, here's this file, and you're going to say, I received this file, and such date, you know, to work with, but you're going to have to disclose all of this to the people you're working with. That's why it's so important to have your log, and
Now, the one process I was involved, my partner invented these series of molding installation tools. Quite nice. You know,
Cool. Yeah, okay.
I never sold any. You know,
well, I understand.
marketing this whole thing, but a great product. But the attorney we had dealt with for that patent gave us a standard letter that we gave to anybody, like the guy who was going to make the molds for the injection plastic.
Exactly.
You know, and they signed it saying, yes, we realize this is your product, and we're just using this information to create. You know,
Yeah, that's what I'm talking about.
Okay.
Yeah, that non-disclosure letter that we're not going to give
So
this
it's something
information.
they sign and give back to you, so
Right.
you put in your file.
Yeah,
Okay.
and that would be probably standard. Your patent attorney would have that, so, you know, kind of whatever
Mm-hmm.
they use. But it's going to be something that says, I received this letter, this information from Tom, and I'm going to, and you know, it's his, and I understand it's his kind of thing.
Mm-hmm.
And it's his idea. So, so that's kind of how patents work. Now, and a design patent is, and the one I was involved in was a coving material, which is an ornamental way to join a ceiling and a wall.
Ah.
It's, you know.
I was in the molding business.
Yeah,
We did
exactly, exactly.
crown
So
molding.
You understand, exactly. Now, this wasn't crown molding, this was just a cove, just an arc, and it was made out of sheetrock material from England, and it was kind of neat, and it was pretty cheap for square, you know, for linear foot. We thought, boy, we're going to get rich off this. Well, you know, it turns out that there's a many a slip twixt the cup and the lip, but as Grandma used to say.
Yeah, my grandma didn't talk
She
like
didn't
that.
talk like that, but well, you know, see. But anyway, so we did that never. But as a result of that, we said, well, we were going to. Then the big problem we had was that, okay, well, how are we going to teach drywall guys who tack up drywall usually how to make miter cuts? Because they don't make miter cuts. I mean, that's not part of their trade. And so,
It's a double miter
The-
cut which is a
well, yeah,
very-
exactly. You had to come. Yeah, that's exactly right. It's a fairly complicated cut. So what are we going to do? And what we decided to do is make the corners, inside and outside corners. What that means is, at any rate, so you didn't have to do anything special. You just go stick the corner up and
straight line cuts. Yeah.
straight line cuts, exactly. So we went and we got a design patent, and my partner and I did. He was more the designer certainly than I did. He did all that work, but
You got the coffee and,
I got the
swept
coffee.
the place
Yeah,
up.
exactly. Yeah. I went to the bank. Yeah. But so anyway, we got it designed, and what we had to do was just that, and it was an ornamental, artistic, useful product.
Mm-hmm.
And so that was a good example of the design.
Yeah,
So it
perfect,
wasn't
yeah.
a machine. It was not a machine. It was artistic. So anyway, now we pretty much and then plants. I really don't know anything about plants, but I'm assuming if you're out there breeding plants or whatever you call it, genetically engineering plants, you
yeah.
probably know more about. Yeah, I would think patents would be a big part of that
Oh,
work.
yeah. You're dealing with high rollers and that.
I think
anyway.
so. Yeah, I think you are too. So we're not going to spend any time on that. We talked about we're going. we're going to have to kind of hurry, Tom. We're going to lose our time. But the trademark, we talked about the trademark as being, again, a logo. And Tom and I are working on a logo right now, and we will be seeking trademark protection for that.
Yeah. Our name, Small Business Doctors, is protected because nobody wants to be associated with us in any way, shape, or form.
I knew that. So we don't have the problem that a lot of businesses do. But, and then finally, the copyright, again, the copyright is only for really works of authorship, poetry, and writings, although it might be fairly technical writings, as long as it was a manual on this or this, that would be copyright material. Poetry, novels, any kind of books, anything that you write down, and you can make that's easy one. You just put the
That's
big
the
C in the
C.
circle.
That just amazes me. I always thought that had to be some very formal legal process to get that.
Well, you'd think so, but it's so darn much that's created every day.
Oh, that's a good point.
It's just thousands and thousands and thousands of that stuff that's created. So they just save your spot in line to go to court on it. It's what they really do, because it shows up. So those are the three basic things. We reiterate, say that 3 times, but we reiterate that we're not here to try to tell you exactly how to get a patent. We're trying to tell you how the process works.
Yeah. And how to protect that idea within a certain framework.
Right, and that
and that is keep that log, that
That's right.
journal or log, whatever you want.
And that you can go forward to develop that and share your information that you may need to share, and at the same time protect yourself. That's all very doable. It's a very common situation, and it happens all the time.
And and I always encourage my clients. They say, "Oh, this might be a crazy idea," and I go, think, be creative. This is how this country got to be as strong and as great as it has
Exactly.
been. It's because people come up with great ideas, and then they had the fortitude to follow through and do
That's
it.
exactly right, and that's what
Dream big.
That's what we like. That's right. That's our mission, to help you dream big.
Yeah.
So, anyway, I think we've got just a few minutes left, and we'll start talking. Do we have? Let's see. What did we want to cover other than that? The patent attorney, and then the patent attorney will also usually, might not always, but be also the guy you go to for the trademark protection.
And having that patent also, and at least having it started and everything, a lot of these ideas are going to require capitalization, and people who are maybe going to pony up money and get involved want to see that idea protected too.
Right.
So having all your ducks in a row, type
Very
thing,
important, very important. And the
that can help you.
non-disclosure
Yeah,
letter.
it'll help you.
Confidentiality.
Yeah, and with the investors too. You give them one
Absolutely.
of those letters too, and
Oh,
go
yeah.
and make sure they sign off on it.
And nobody's going to be totally surprised about this. This is just standard stuff as long as you know it. They're happy to take your non-disclosure. Now, if you find somebody who's working on the same idea, he says, no, I don't want to look at your stuff. Because
Yeah. So anyway,
Well,
we're-
again, thank you so much for us. Good night.
have